Call this work session order. This is a work session dealing with towing. Let's go around and identify ourselves for the record. Julia, we'll start with you, ma'am.
Julia Tucker, Assembly Council.
Bernie Hall, Anchorage Assembly.
Tim Stevenson.
Bill Evans.
Dick Trainee.
Peterson, Assembly.
Melvin Gray Johnson.
Daryl Hess, Municipal Ombudsman.
Barbara Jones, Municipal Clerk.
Amanda Moser, Deputy Municipal Clerk.
Dean Gates, Assistant Municipal Trainee.
Welcome. I appreciate all of your work on this ordinance, so let's get into it.
All
Barbara?
right, I've
wanna lead off?
got the lead here, but before I start, I think I have to say thanks. You can see this is a big team here, and we had lots of help from everybody here on the front that's going to be talking a little bit to you. We also had help from Mr. Trainee, Mr. Koneman, prior assembly members who probably worked on this, and some other people that are in the audience, Connie Ernst, Risk Management, and Mindy McCauley from APD. And I'm sure there's others that I'm forgetting, so thanks to all of them. So you've got a handout right here that the team prepared, and so what I'd like to show you about the handout, outside of the fact that it's in blue and yellow to emphasize our muni colors, the first page is the highlight, and then I've got a divider, and it's going to tell you about 9.54, and Dean Gates wrote the 9.54 section, and then the next divider, yellow divider, precedes the 10.54, which is the business licensing section, which Julia Tucker wrote. So it just gives you some idea of what the divisions are. It's a lot of information, and we kind of wanted to break it up a little. So,
You know, Barbara, looking into this, I find the last time this one was rewritten successfully was 1983. My old predecessor, Lydia Sobering. There's been numerous attempts since then to deal with this, but this will be the first time since '83 it's been completely dealt with.
and so Daryl and Amanda are going to talk to you about some of the issues that the municipality, the clerk's office, who deals with the licensing, and Daryl, who deals with complaints from the city, they're going to talk to you about some of the concerns that they've had. And that's part of the motivation that Assemblymember Trainee and Koneman had to get this code rewritten. So just to look at the very first page, I want to talk to you about the highlights. And again, the team worked on this, and this is what we think are the highlights of this ordinance. First, it creates a consumer bill of rights regarding towing. It's a consumer protection ordinance. We think that's really, really important. And one of the issues that we've discussed numerous times is that someone's private property is being taken. And because it's been illegally parked or parked in a wrong place, but even though their property is being taken, so some of the issues in this ordinance focus on protecting people whose personal property is being taken. The second thing, bullet here, is it talks about the difference between three types of tows. And this is really important to all of us. There are consensual tows, there's a rotational tow program, and then there's non-consensual or private party impound tows. And I know that Julia and Dean can help me with this. Number one, consensual tows rates are not regulated by this ordinance. Number two, the rotational tow program is administered by APD, and that's why we've been working with Mindy McCauley from APD. She can answer your questions about the rotational tow program, where APD tows vehicles that are being, later in the ordinance, it talks about public impounds. Now, the focus of this ordinance, although it has some cleanup in lots of areas, the focus is on non-consensual or private party impound, or PPI tows. And I think when you hear from Daryl and Amanda, you're going to find out that those are most of the concerns that the municipality has received regarding the PPI, or private party impound tows. So then, to get into the details, the third bullet talks about the caps on the rates for non-consensual private party impound tows. It puts a cap on the rate of $225, and that was a number that Mr. Trainee and Mr. Honeman selected with some discussion from the group, looking at other rates around the country and within the municipality of Anchorage. The next thing that's really important in this section is the prohibitions. It prohibits predatory rates and predatory practices. And I've cited the section, and we can get into that later in the section by section if you're interested. A predatory rate, for example, is a rate for swearing. So if the citizen comes to get their vehicle, and we have had examples of this, so they're picking up their vehicle from the tow yard, and the rate is, let's say, $50 a day, but the citizen swears at the tow operator, they get an additional fee for bad language. And that is prohibited in the new code. There can't be other fees. There can't be gate fees or wait time fees or other fees added. It's $225 for the tow and transport to the storage yard, and then there is a storage fee, and then there's a after-hours access fee. There can be a curb release fee, but there can't be what are defined in the code as predatory fees. Then there's some other prohibited practices in this section. Some examples of a prohibited practice would be you have to pay before you can look at your vehicle. So the property owner, the owner or operator of the vehicle, can look at the vehicle, can see the photo of the vehicle where the vehicle was towed, can see the violation for the reason the vehicle was towed, gets an itemized bill, and then the person can pay to get the vehicle released. But they don't have to pay and get the vehicle like in exchange for if you don't challenge this tow or something like that. So those were considered predatory practices, and they're prohibited in this new provision of the code. I'm at the first, second, third, fourth bullet. So a curb release. This is a situation where if the owner or operator walks out onto the scene and the car is in the process of being towed, we define what it means to authorize the car to be released before the tow operator completes the tow. So it's kind of a three-step process. If the tow operator is in the process of hooking up the vehicle, then the person can get the vehicle released. If the tow operator is in the truck, then there's a $50 charge for the on-scene release. But if the tow operator is moving, then the requirement is only if the tow operator sees someone trying to flag them down, only if the tow operator can safely stop does the tow operator have to release the vehicle for the curb release fee of $50. So that's a new provision, but something that the public has been very concerned about, that they'll walk up on a vehicle that's in the process of being towed and they'll be charged $400 rather than just some lower rate for releasing the vehicle at that time. The next one is the signage. Now there's two types of signage, and one is the code has always required signage at the tow operator's place of business and at the private lot where the car is being towed, either the parking lot or a parking facility. So we're just clarifying that that signage is required before they can tow. And I think we, again, believe that that's a consumer protection issue. The licensing requirements now have changed. So we've switched from the towing procedures, which are in 9.54, to the licensing requirements, which are in 10.54. So there's going to be a new application and licensing requirements. There are really many of the same things that are already required. They're just not detailed in the code. And one of the things that I'll acknowledge that I've asked our drafters to do is to make it sort of a cookbook so that it's easy for the public to understand what it is they have to provide, but it's also easy for the clerk's office to implement. We can all understand it because it's just detailed real clearly. And I think I have it somewhere else in the code. It's like 11 steps in that provision, so it's a lot of steps. But all the documentation was already required. To get a business license for a tow operator, you have to have a state of Alaska business license. You have to complete the application. You have to pay the fee. You have to have vehicle registration. We're just lining it all out as items in the code. Now, there are some changes though with the fees. As you can see in this bullet, the application fee is now changing to $150 a year. It used to be $200 every 2 years. So it's an increase. It's not a big increase, but it is an increase. There's a $20 sticker per tow vehicle. So if a company has one tow truck, they pay $150 and they get one sticker with that tow truck. But if a company has two vehicles, they have to pay $150 for the licensing, they get one sticker with that license, and they have to pay an additional $20 for the second vehicle. That isn't a change. That's all the way the clerk's office has done it now. The stickers are pretty expensive. How much do they cost us?
$8.65 a sticker.
So that's why we need to charge per sticker. There's a new change, and the new change is that we're requiring this PPI endorsement. That's the private party impound endorsement. So what we understand is that there are tow operators who do consensual tows. They tow my vehicle because it broke down on the Seward Highway. I'm calling them up, and I have a contract with whatever tow operator works for AAA, and they come and tow my vehicle. That's a consensual tow. So operators who do consensual tows would not need this PPI endorsement. Operators who are part of the rotational tow program at APD, if that's all they do, they would not need a PPI endorsement. The only operators that need a PPI endorsement are those that tow vehicles from private property. And the reason that we've added that endorsement is because that is the source of most of the concerns that have been raised either with the clerk's office or the ombudsman's office in the last years. So to reflect the cost of dealing with those tow operators, there's an increase fee. There's also a separate page, the application for the tow operator. It's going to be a 2-page application. One page just for a tow operator that does consensual tows or is in the rotational tow program, but then a second page for operators who want the PPI endorsement. All right, last, and I've just made another bullet about the required PPI impound because that's important. It is a big change, and we just want to emphasize that that's a big change. And then the last bullet, it clarifies the fines, and that's in section 3 of the ordinance. Those are going to be in Title 14. And then it specifically defines prohibited conduct, and I've already talked to you a little bit about that. But I think those are significant changes, so I just wanted to point those out again to you. And I am right on schedule with my time to discuss this. So I'm just wondering if you have any questions. Again,
If you have any questions on her part, when we get done with everybody else, we'll go through it, so maybe we'll just go through this. Anything on what Barbara said? Heather?
Thank you. My name is Amanda Moser, as I said before, and through the chair, I just want to talk a moment about the mind map that we passed around. This group that worked on this specific ordinance, we originally got together in the summer of 2013, and we, as a working group, sat down and addressed all the concerns that we had heard over the years about tow operators, specifically from constituents. So I have worked in the clerk's office since 2010, and I, since 2010, have received feedback from the public on concerns with their vehicles being towed. And so we worked with Daryl Hess in the Ombudsman's office, the municipal clerk's office, to sort of address these issues over the years that have been brought forward. And then from there, we were able to produce this ordinance. But I want to take some time and talk about some specific complaints, just so you can kind of, I'm not going to talk about all of them because we don't have weeks. But I am going to take just some time, and I'm not going to mention the name of the constituent who brought this complaint forward, and I'm also not going to mention the name of the tow company that they are addressing in this. And some of these you might be familiar with because you have also received these requests. So July 31st, 2014, so this year, I had a woman who contacted me who used to be a teacher in the Anchorage School District, and she has since moved to Arizona, but she came back to visit some friends, and she was over at a condo in the Eagle River area. She was having tea with her friends, and she was just there for an hour, and there wasn't very clear signage where she parked, and her vehicle was towed. For her 1 hour tea with her friends, she had a $475 tow charge. So she had, $425. She had a $300 impound fee, a $75 mileage fee because it was towed from Eagle River to the Anchorage area, and then a $50 gate fee, and she did pick it up that very day. So very expensive tea with her friends. I received this in January of 2012. I live in the Hampton Greens complex on Barrington Loop, and a guest of mine was towed. It was late Friday night, and my guest was at my place for approximately an hour. The complex is full of snow, and signs are not very visible, especially at night. Regardless, when he left a little after 11 p.m., he found that his car had been towed. The police had no record of it when they called. Finally, he found out and made contact with the business that towed the vehicle. They told him he would have to wait until Monday to get his vehicle back, and that there was nothing else they could do. Obviously, this is not acceptable. I'm just reading her email, not my specific thoughts. Several calls to the police and to the company were made in an attempt to get this resolved. My guest had his house keys and baby car seat in it, and waiting until Monday was not acceptable. His wife has asthma, and her inhaler was in the car. The company would still not release it. At some point in time, the company said he could get the vehicle back if he paid $485. So, and then this is more of her commentary. That is $485 for having a car for less than 30 minutes. My guest was told that he was not telling the truth about the inhaler and stalled and was hung up on once more. The only way he got his car back was that he showed up at the company's location at 4 a.m. and he had to wait for the driver to appear. So this is from May 8th of 2013. Last Friday night, I met a friend for drinks at Gallows on Diamond Boulevard. I had one margarita too many and decided to get a ride home because the Gallows parking lot was full. I left my van parked into the lot immediately adjacent to the restaurant. When I tried to retrieve my van the next morning, I discovered that it had been towed overnight. The fee to get it back, $320. The company told me that we don't set the rates, the city does that. That sounded strange to me, and in talking to some of you since then, it sounds as though the assembly merely approves the rates filed with the towing contractor. Whatever the case may be, I would like to offer that $320 seems a ridiculous penalty for such a minor offense. I was not parked in a handicapped spot, blocking a fire hydrant or preventing snow plowing. I assume, well, fortunately, I was able to pay the fine and get my car back. Many people in this community could not afford to do so. However, and it strikes me that some might risk a DUI in order to prevent getting towed. So, I had another person this is April of 2012, who had improperly parked, and their vehicle was towed by a company, and they had a $400 fine, and they had to wait. They were towed on April 7th, and they had to wait until April 9th before they were able to retrieve their vehicle. And then I have a whole series of complaints from the downtown area. There's a business owner who, I think almost everyone in their family has been towed, and their tows are anywhere from $383 to $331. And one of them was able to avoid the towing by paying $200, and they had to pay it in cash. So over the years, there's just been a collection of sort of these stories that varying fees and varying sort of circumstances, but it's all very similar in the note that it was just a simple one sort of time thing that happened, and then these sort of extreme fees were charged.
Thank you. We're still ahead of schedule. Do you have any questions for Amanda, or we'll go?
Is what Amanda or Barbara's covered? If not, let's go on to
Daryl.
All right, thank you.
He's where the rubber hits the road at too. Besides Amanda, she does a great job. Daryl gets a lot of the citizens' complaints coming into him. In fact, he's got some personal accounts where a gentleman went to the bank and they've got a sign there, only if you're shopping at the bank can you use their facilities, can you park there. Well, the guy was using the electronic bank. He was still trying to tow him away. Daryl?
Thank you. Once again, my name is Daryl Hess. I'm the municipal ombudsman. And I have to say, our office, the two areas where we get the most complaints are both non-jurisdictional for our office, and that's landlord-tenant issues and private party impound tows. And coincidentally, they both involve civil remedies. And personally, from our perspective, we believe in our office that that's one of the issues with the current code. The burden is on the citizen to take the tow operator to civil court, and a lot of people don't have the resources or the knowledge how to navigate the court system. So we believe that puts an undue burden on citizens. And in our experiences, a lot of, nobody's happy when they call. Nobody's happy to have their vehicle towed and impounded. And in many cases, the code is followed, the signage is done correctly. Because somebody's unhappy doesn't mean that anything was done incorrectly. And in our experience, the majority of the tow companies follow the rules, or attempt to follow the rules. But there are times that the rules aren't followed, and Mr. Trainey had a good example. Our staff, before Starbucks closed over by North Rim Bank, every Tuesday morning about 8:45, we would walk over there and buy coffee before our staff meeting. One Tuesday morning, about a year ago, I observed an older gentleman. He was at the option machine at the North Rim Bank as we were walking in. And as we were walking out, a woman came running up to us and says, "Is that your vehicle over there? Does that Bronco or Blazer belong to any of you?" And we looked around the corner, and there was an older white Bronco or Blazer that was being hooked up, was being towed. And it was parked in a spot that said North Rim Bank customer parking only. I think it was 6 a.m. to 6 p.m. Monday through Friday. This was about 9 a.m. And about that time, the older gentleman that had been at the option machine came running around the corner. He's going, "This is my vehicle. What are you doing?" And the tow driver said, "We're towing your vehicle. You can't park here. This is for bank customers." He said, "I was at the bank. I was using the option machine." And the driver said, "Prove it to me." And he said, "Well, the machine asked me if I wanted a receipt, and I pushed the no button." And he goes, "Well, then I'm going to tell you." And so Betsy and Heather and I said, "Well, we all saw him at the option machine." "Well, it doesn't matter. I need proof." Then the bank manager came walking around the corner and said, this gentleman's a customer, he was just at the auction machine. And the driver said, I need proof. And she goes, I'm the bank manager. The sign says bank customers. It says, I need proof. So I looked at the citizen who owned the vehicle, and I looked at the driver, and I said, are you going to offer this citizen a curb release as required by the code? He goes, yeah, $150 cash only. And I thought, well, you know, he could ask you for written permission from the property owner manager to be towing. And he looked through his binder and said, well, I can't find it. So long story short, he eventually released the vehicle. But nobody had called that driver. The company had the contract to patrol that lot. And because the sign said bank customer parking 6 a.m. to 6 p.m., the bank, I don't think the lobby opened to probably 10 a.m., he naturally assumed any car parked there was in the Starbucks. He didn't see the gentleman walk around the corner and go to the bank. That's one example. We had another citizen contact us. It was a Friday, Saturday, I think he was at Chilcoot's, and he parked on the street next to Ray's Restaurant. Comes back out, his vehicle's gone. He calls APD, somebody stole my vehicle. And APD says, well, it's been towed and impounded for parking where it shouldn't on private property. And the gentleman contacted the tow company and said, well, it was in the road. And this guy was pretty smart. He went to the permit center on Tudor Road, pulled the copy of the plat to show that he had parked on a public street. He took pictures of the building. There was no sign that said no parking. He contacted our office and he said, well, I want something done. They stole my car. It was on a public street. Well, once again, it's a civil remedy. So Heather McAlpine, our associate ombudsman, explained the requirements of the code to him regarding signage and written permission, and if you don't have all the proper, if you don't follow the rules and it's not signed, and it's towed from a place that the private party doesn't have control over, you can go to civil court and you get your money refunded. This gentleman called the tow company, made his case, and he got his $650 back that it cost him to retrieve his vehicle on a weekend. We get a lot of phone calls involving trailer courts. And I'll give you an example. This I heard actually as a member of the Equal Rights Commission. There was a gentleman had a vehicle parked in his parking space, on his lot in a trailer court. And he'd had a temporary tag on the vehicle. Well, it had expired. There was problems getting the license plate from the dealer. He had the new temporary tag in his glove box. He hadn't put it on yet. And it had snowed. It was like 4 in the morning. The vehicle was covered with snow. So the tow company that had the contract for that trailer court drives around. They had seen the date on his tag earlier, obviously. They brushed off the window to see if it had expired, and they towed him at 5 in the morning from his parking space in the trailer court. He had the new tag in the window, but he didn't think he needed to put it on right away because he was parked. He wasn't parked in the public right of way. He was parked in his parking space. We get complaints from trailer courts. We had 6 people from one trailer court contact us that the manager of the trailer court patrols the court with the trailer court operator looking for tows, and that manager receives a commission from the trailer court, or from the tow company. Once again, these are non-jurisdictional for us, but we do the best we can to try to assist citizens and explain to them what their options are under civil law. But it's an undue burden on citizens with no regulations, no fines on the part of the municipality. We get a lot of complaints that curb releases aren't offered. People will come out of Fred Meyer or come out of different stores. Their vehicle's there, it's been hooked up, but they haven't started towing it yet, but they don't offer them a curb release. We get multiple complaints involving signs, that the signs don't meet the requirements of the code. And even though it's non-jurisdictional, sometimes we will drive out and look, and I will tell you, based on personal observation, a large percentage of the signs in this city do not meet the requirements of the code. They don't have the phone number where you can retrieve your vehicle. They don't meet the size requirements. Downtown Grill in my neighborhood, or IE, I think the signs are about this big, which is way under the requirements of the code. So there are multiple issues that our office would like to see addressed in the code. And I know we have seen times when multiple tow companies have been operating for months with expired municipal tow licenses, including towing at the behest of the municipality with expired licenses. But if there's no incentive to not have expired licenses, will we see any improvement?
You've got two more people, you've got Dean Gates and Julia. We'll take the question on the same as soon as those two are done. Yes, Barbara?
I have a couple of comments that I'd like to make regarding some of the things that Daryl said. And one of those is thanks to Mr. Trainee and the Assembly as a whole. Former Chair Ernie Hall asked me a year or so ago if I was queen for the day, what would I want? And I said, code enforcement officer. And so you added that to the budget for 2014. We are paying for one code enforcement officer at the permit center, and the purpose for that code enforcement officer is to enforce the provisions of Title 10. So some of those already exist, and Daryl mentioned a number of them. Not having a current tow operator license, some of the other issues, I can't remember specifically what they are, but we're going to have a work plan developed from the Code Enforcement Division that'll help us monitor the tow operators as well as other licensees under Title 10 and make sure that we're following up on enforcement. Some provisions in the code that address some of the issues that Daryl talked about is Dean wrote a really good section called public impounds, and he makes it clear that if you're violating a municipal traffic rule, for example, like not having current tags, then those can only be towed by a law enforcement or code enforcement officer. You can't have a tow company towing from private property for what is essentially a code violation. And that's one provision that we've added. The other one is called an anti-kickback provision. And I think Daryl mentioned that as well, where the mobile home operator, we've heard of condominium association, people who are getting a bonus or a gratuity or something to that effect from someone at the condominium association, and that'll be prohibited under the new code. Then, so those are some of the things I wanted to address. You guys can probably think of some others that Daryl mentioned, but there's one other thing I'd like to cover before we go to Dean and Julia.
Let me just add for the record that we've been joined by Ms. Dombrowski from Eagle Ridge, Birchwood, and other points.
Good morning.
Good morning, ma'am. Go ahead, Barbara.
Dean did a really nice analysis for us and wanted me to mention a couple of things that might be out there that might not be exactly correct about the new towing ordinance. One comment concerned the covert observation. It's not an absolute prohibition. A member of the public or a tow operator can observe people parking in a vehicle or parking in a lot that's signed correctly, as Daryl mentioned. However, if they're observing either with an electronic device or a person and someone gets out of the vehicle in violation of the signs, either the electronic device or the tow operator have to say, hey, you're not supposed to park here. You have to give an audible warning. And what we're saying is we think that's fair. If you're observing in the lot, we just want people to get a warning. So it's not an outright prohibition of electronic observing. Another issue that we've heard about is that Daryl mentioned that people have to pay cash to get their vehicle released. And there isn't a requirement that tow operators accept checks or credit cards. The requirement is if the tow operator has an office or regular place of business and they accept various types of payments, then they have to accept those same types of payments at the tow vehicle. So if they accept only cash at the office, then they only have to accept cash from the tow operator at the tow. If they accept cash and credit cards, then the tow operator needs to accept cash and credit cards. We think, again, it's just a fairness issue. Another one is that the concept that people are allowed access to the vehicle at the tow impound for free. But it doesn't mean that the tow operator has to give them a free trip to the tow yard. That's not what the requirement is. The requirement addresses the issue that Amanda was talking about, where they had a car seat and an inhaler in the vehicle. Well, we want to make sure, and Mr. Trainee used the example of eyeglasses. So if we've got someone that had their vehicle towed, we want to make sure they can get their car seat, their medication, their glasses from the vehicle, and that is a free access. So it doesn't mean that during regular business hours. If you want to go during the middle of the night to get it, then there's a $50 after-hours access fee. We recognize that that's a burden on the tow operator, and they should be able to charge that. But if you want your glasses or medicine in the middle of the night, then you need to pay for that too. Then the other requirement that we noticed that there was some discussion about was, and Daryl mentioned this too, the contacting APD. So it is currently required in the code that the tow operator has to contact the APD if they're towing a vehicle. And it's obvious we don't want people like the gentleman who was at Chilcoot's calling APD to say my vehicle was stolen. The vehicle was towed. So the new requirement is they have to contact the APD before initiating the tow, and they get an incident number from APD. And then after they get the vehicle to the tow yard, they have to call within an hour. Now remind me, what was the requirement? What's the current requirement? I don't remember that exactly.
For the notification to APD?
Yes.
It's to notify the APD within 1 hour after arriving at the tow yard.
Okay,
That was the requirement.
so now we're adding a requirement that they have to contact them before initiating the tow as well as within the hour.
Yes.
Okay.
Mr. Evans, sir?
Just a quick question, Barbara, clarify. You were saying about retrieving property and stuff from the vehicle and the impound, the access. Did I understand correctly that if somebody has their vehicle towed, presumably properly, they're illegally parking private property, let's say, vehicle's towed, it's in the lot of some tow operator, 3 o'clock in the morning, I decide I want to get, whatever it is in my car, and then the operator has to let me in for a $50 charge.
Well, I'm not positive I would say that that's mandatory, but if they do let you in, it's a $50 charge. Okay, so is it, I'm not sure that that's mandatory.
I don't believe the after-hours access is mandatory. I think, if I recall correctly, what it says is if you offer after-hours access. But one other point to make here is we do have required business hours, so we do have to have availability for access between 6 a.m. to 6 p.m.
6 a.m.
So that's designed to allow someone early in the morning for work to go and retrieve what they need from the vehicle.
Can I follow up?
Go ahead, sir.
That was 7. I need to take a look at that. So I can answer.
That's fine, yeah. Question for Daryl, and it's probably a personal question. I have a spot I rent downtown for parking. It's got a sign on it, no parking, you can tow it at your own expense. It doesn't have a phone number on it, which apparently is part of the regulations. How is it that, a person such as myself or anybody downtown or anywhere can have a phone number on it when you don't know? I don't have a relationship with a towing company, so I park in my spot, I call a towing company, but I don't know which towing company I'm going to use, so I can't put that phone number on the sign. How is that supposed to work?
I'm not sure, I'm not an expert on that section of the code, but I think it has to do with the type of property that it's being towed from, the size, the number of parking spaces.
Yeah. Dean is the
I could
expert on
try
that.
to address one of that question. That might be the case in some instances. What we try to do is protect the consumer, so if a car is gone, don't worry, you don't have a phone number. I think most people would call it APD, my car is missing. That's why we require the tow operator to call APD, get an incident number before they start the tow. So when it comes to the car is gone, there's no phone number, they hopefully would think it's called APD. We'll have a list of which vehicles have been reported as towed and give them the information as to when it was towed, where it is. That's the information the operators require to give the APD as well after they arrive at an impound yard. That's why we have the second call follow-up to APD. Where was it towed to? Where is it stored now? And so APD would have that information. If there's no other way to find out who towed where it is, it would be APD.
Is that currently how it operates? I mean, is it that requirement to call APD or?
Okay, yes. So the answer is yes, they are currently required to call APD in 1 hour of the tow. So now we're just adding the requirement on the front end that they call APD and get the incident number prior to initiating the tow.
And
Let me get Mr. Browski, and then I want to get on to the engaged 9.54 and then Joey with 10.54.
No, I was just gonna say, I put APD's number on the sign.
Dean? Here's your,
Okay, thank you, Mr. Trent. Thank you, Assembly members, for being here and everyone who's come through today. And thank you, Barbara, for your kind comments on my drafting. I drafted most of the 9.54 revisions. And if you have trouble understanding me, just ask me to repeat myself. I have no problem with that. This is something that I think is not happening just in Anchorage, but across the nation. Several other local jurisdictions have revamped their tow operator codes and their towing regulations. So we have seen, for example, Seattle and Portland have completely revamped their tow operator code past 2012 and 2013. And that's very helpful because we're able to draw on what those other jurisdictions have done to help in our drafting here. They're often facing the same problems, predatory towing, unfair practices, and things like that. So, and many of them are also oriented towards consumer protection, but also being fair to the tow operators. So we see various features that are in our draft that have been drawn from other jurisdictions facing the same issues. Now, my part was primarily to draft changes to 9.54 for our common needs. 10.54 is something that Julia Tucker, Assembly Council worked on. The difference here is basically 9.54 addresses the rules when tow operators are conducting a tow, rules when they're out there in the field working. 10.54 is about licensing, whether the licensing requirements, insurance, and record keeping, things like that, how to operate the tow business. So that's generally the difference here. What I thought might start out as a 3 pages project is now blossomed into 31 pages. So I don't want to go through everything, of course. And Barbara hit a lot of the highlights that we had discussed beforehand. So I'm not sure what additionally I want to hit on here, if there are any specific areas of the process.
Dean, you might want to talk about the rates, setting it at $2.25. We put an escalator in there, but if the rates are not raised, then there's a cost of living index after about 5 years that would increase the rates. And we put into here, too, dealing with distance and towing, a surcharge. One question was, would Girdwood still get towing? And the answer is yes. We put a fuel surcharge in here, anything over 20 miles. And that deals with equal to get Ridgewood. So we dealt with that. And then Dean was very nice when he wrote this Consumer Bill of Rights regarding, I like to call it non-consensual towing, but they've got down here regarding towing. Because, I was talking to a guy last night who got towed. He said, yeah, I got towed and they told me I could take it to small claims court, so I did. And then they got an attorney to file a document that waived small claims court. And they thought I didn't have an attorney. My best friend's an attorney. So then I followed up and they immediately dropped the case and returned my car to me. So, anyway, Dean, go ahead. If you want to go through these or not, it's up to you. I mean, we can read them, but I appreciate your work on here.
Thank you, Mr. Chairman. I suppose that one thing to mention is this is probably a good product. I wouldn't say it's perfect though. So we do have several public hearings coming up and things like that. There is, I think, it's very ripe for an S version additional changes. So of course, I think we have released this to the public a couple of days ago, and so we'll have a lot of stakeholders that will want to have a voice in what we've done here. And I think that, for example, Mr. Fees, this applies to mostly non-consensual PPR restrictions, so 225, and we tried to make an adjustment. This is in code, so it is after 5 years, for example, as you mentioned, needs to be raised because the cost of everything is going up. It needs to be done by a code amendment, which needs to go through the assembly. But if you know that doesn't happen, we have that automatic adjustment in subsection B. I'm looking at page 78, this is section 9.54 non-consensual towing rates and allowable fees. And we've tried to list out every fee that's allowed. We had some guidance from state statute. There's a state statute about towing and storage liens. So when an operator tows a vehicle, they have a lien against the vehicle. They can sell the vehicle if it's not claimed and retrieved from storage by the owner or the owner's agent within the allowable time by law. That lien's restricted though. It can't be anything. For example, profanity fee, being rude and things like that. They can't add that to the amount of points sell the vehicle for the storage lien. This says only towing and storage charges. We try to classify here everything that might be towing and storage charge. At the end of each of those items 1 through 6, it might say this fee is a storage charge, for example. That would be something allowed to collect under the lien. There's some that aren't. So, yeah. And I think that this list I already had in my mind, that maybe number 7, maybe even keep that in mind as we go forward with this. I think that we also wanted to point out 9.54 this is telephone access for the tow operator for non-consensual tows. Because it's so important, you know, as Mr. Evans noted, how do you find out where the vehicle is? If there's a phone number, we want that phone number to be accessible 24 hours around the clock, 7 days a week. It's Christmas Eve, your car's towed, you want to be able to call and know where is it. You can get home for the holiday. So we have that requirement here at all times. Information is not required to be answered, it's required to have certain information on the telephone access. So we have that listed in 9.54. It doesn't require the office to be open. We, when drafting this, tried to take into consideration the fact that there's some small tow operators, perhaps they only have the tow vehicle and that's it. Maybe they contract for storage somewhat. But if they have a non-consensual tows, PPI tows, they need to have a telephone access somehow, answering service, a cell phone, at all times. We have the 9.54.45 on page 9, storage yard in the city. We have been through drastically right of Title 21, so taking that into consideration, we want to make sure that towed storage yards are in compliance with the land use code. That's what that section is about. We also recognize, and I thought this would be a jurisdiction that maybe for some reason that tow and storage yard is listed on the application isn't available, so we have subsection B allowing it to be taken to an alternative application as long as the tow operator notifies the clerk as soon as possible. The next business day, it is. We have, well, in 9.54, this section is probably of most interest to tow operators. This outlines pretty much the procedures on the street for, you know, towing away, on-scene release, things like that. It goes on for a few pages, so that's something to look at hopefully. We have.
Sure. Mr. Evans has a question.
Yeah, we were talking about the fuel surcharge previously, and I just looked at what it was in the ordinance, and it looks like it's anything over 20 miles, you're allowed 10% of the tow charge, which if the tow charge is $225, that's $22. which seems like it'd be pretty inadequate to go out to Girdwood for an additional $22. So to the extent that there is going to be an S version or anything, I would really like to see that addressed so that it's more of an incentive so that they can get towing into more far-flung.
Can you give us a language of what you want to do?
I'll work on something.
If you would, please. Because it's worked with the entire body. We've been joined by Ms. Johnston. Welcome, ma'am. Anything else, Mr. Gates? We'll move on to Julia. Yes?
And to that point, probably you want to do the same for either
Nah.
Not true.
Okay. You two are in opposite corners. Thank you, Dean. Let me move on to Julia because we've only got about 10 minutes left for this segment. Julia?
Thank you again. My name is Julia Tucker, and I'm Assembly Counsel, and we really owe, as Barbara has said, quite a bit to Dean Gates on this, because the Assembly as Mr. Trady, you're the most familiar with, has several times, in conjunction with the clerk's office and the ombudsman's office, attempted to do what's being presented here, and it just hasn't been able to come together. I worked on it and actually ended up presenting a paper to the International Municipal Lawyers Association back in 2011 with the expectation then that a lot of what we were doing in conjunction with the clerk's office would come to fruition here. I'm going to pick up just for a minute or two with Chair Trainee's introduction here about the 1983 ordinance, and that is something that was introduced by Assembly Member Selcraig, and at that time the licensing and the tow procedures were combined under 9.54, and in that ordinance it was to facilitate towing practices from private areas, similar to situations that everybody's familiar with, and that Assemblymember Mr. Evans has given an example of. But even in that ordinance, going back then, the tow charges were to be reasonable. And in that ordinance, you had the contact with APD, and there was a clause that said any fee which includes a fine or penalty shall be deemed unreasonable. And those of you who are aware of examples as Barbara and Daryl have talked about, and we've seen in the newspaper recently, when you're charging one amount for curb release and then adding an amount for somebody's attitude, or adding amount if they're swearing at you because they're anxious that their car is being towed, those are fines and penalties. That's what the 1983 ordinance was prohibiting. So that's not new. Also, in the change that Barbara talked about in terms of having going from a 2-year license to a 1-year license, the Assembly passed that ordinance. That piece of the presentation here earlier this year is the first step of getting our arms around this. And then what in the licensing situations Barbara's talked about that is new to this one is to have the private party impound endorsement. And the rationale that other jurisdictions have looked at, that we were able to actually, as things have evolved, look at the final product in Seattle after it's been had some time of implementation. Also Portland, the cities like Anchorage, whoever is in charge of the licensing and the administration of tow operation has found that the focus of all the complaints and their actual ministerial and enforcement work is not in the consensual tows, not when you and I call up somebody and say that we need our car taken to our garage, or a mechanic's garage, not the roadside assistance. All of the consensual tows are, we don't get complaints that the fees are unreasonable. We can go through the phone book, and if it sounds too high, we go to the next guy down the lane. And those tow fees, as of last year, 2013, for within the city are like $50 to have your car picked up and taken to your mechanic's garage. Those are consensual tows. So it's kind of a reasonable basis. That's not the bottom, but that's kind of the sense of competition there. Rotational tows. That's a program that's has been administered by APD since about 2000, and we don't have any problems in that area. Those are working fine. So what comes along are complaints about the unreasonableness of fees, the fines and penalties that are built into fees, the fees that are add-ons that aren't authorized in the lien situation for storage and towing. And that's what this ordinance addresses there. It sets, along with access and other fees, sets a bar around, or not a bar, but some partition sort of about what's reasonable. And as Mr. Trainee knows, there was a reorganization of the 1983 ordinance in 2005, and it sort of separated out the tow procedures from the tow licensing sections, but didn't change the language of the tow licensing much. But an expectation at that time was that the private party impounds would somehow be reflective of the same type of rates that were used in public ways. And when that happened, that ordinance was implemented, was passed by the Assembly and began implementation before I started working with the Assembly, and I started in the end of 2005. But one of the first things that Mr. Trainee handed me was a complaint by, I believe, a former state legislator who said, why, aren't these rates more in line? And so that's how long we've been working on this.
It is 12, we've got to end this
I'm
portion.
done.
Now, questions from Assembly members, you get them to Barbara. We'll try and get an answer for you. Now, there's a public session for the public to comment on this on Wednesday at 11 o'clock. We've got our Public Safety Committee meeting. Then, of course, public and comments, we want them to, when it comes in front of the Assembly.
Mr. Trainee, 12 to 2.
12 to 2?
12 to 2. It's the
been changed.
regular Public Safety Committee meeting at the library.
Okay.
It's 12 to 2. And then
I'm
we
just
have
looking at my phone and gave me a different time. I'll use yours.
2 public hearings on this item at your meetings on November 5th and November 18th. So we've got lots of time to hear what the public has to say and take your comments.
Part of the reason for doing this is because we want to take action before December. Because the way the thing is structured is they get their licenses by December 31st. So we want to have all the licenses. And I've asked the clerk's office to give us a list of last year when tow truck operators renewed their licenses. There's about $500,000 we've left out there on the table. Because the fine for not renewing your license is $500 a day. We have a lot of people that didn't renew their license for 90 days.
And
Yes.
just one follow-on to that. That
But they were still
fine
towing.
schedule has been in the code under 10.05, where all the fines are. And there's been a provision in code for years that says that the licensing, when you don't follow the licensing requirements anywhere in Title 10, including 10.54, that this is the fine. In this schedule, we've we've gone and put those out so that everybody can see them more clearly under Title 14.
And I also just wanted to mention that people could provide feedback through the wwmas@bb.org email account too.
Thank you, everybody, for being here. This work session is over. We'll start the next one.